Okay, before we start talking about the right of privacy, I want to have a couple of conversations. The first thing that I want to talk about is the Chief Justices of the Supreme Court. Now, I'm in Wikipedia. This is never a good place to go for factual information, because you notice every entry that is here has an edit button and anybody can go in and change that. Now, I have been able to verify that today the information that is listed here is not exactly a hot topic, is accurate. So I'm just going to scroll through this list of Chief Justices of the Supreme Court. And they are all Caucasian men of some significant age. And our present Chief Justice of the Supreme Court is John Roberts. Before John Roberts came in 2005, the Chief Justice was a guy named William Rehnquist. And William Rehnquist actually passed away in 2005. Before William Rehnquist, it was Warren Burger. And just notice that each of these people has a president's name beside them, because that's the way you get the job as a federal judge. You have to be nominated by a president and then confirmed by the Senate. So before Warren Burger, and Warren Burger was there from June 23rd, 1969 until September 26th, 1986, was this tall guy named Earl Warren. Earl Warren had been the governor of California, and he was appointed by Dwight D. Eisenhower. He was a Republican, and Dwight Eisenhower was a pretty conservative Republican, and he had gotten wind that Earl Warren might be running against him, and he wanted to make sure, well, he just wanted to kind of get Earl Warren out of the politics game. Earl Warren had kind of always been a thorn in his side. So what he did was decided to give him a lifetime appointment on the Supreme Court. And so Earl Warren was a California Democrat, meaning that he was not necessarily really conservative. And in some instances, he was actually quite liberal. And courts have a tendency to take on the personality. If you look at the decisions that were made by the courts when certain Chief Justices were there, they have a tendency to take on the personality of the Chief Justice of the court. For instance, John Roberts is a very reserved, thoughtful Republican, moderate to right-leaning, and a lot of the decisions that come out of the Supreme Court, or that have come out of the Supreme Court, have a tendency to have that feel. We're going to look at the law. We're going to separate how we feel about the issue itself from what the law is, and sometimes you're going to get some surprising decisions. So Earl Warren, I call him Crazy Earl, I'll be honest. Earl Warren had a tendency, the court under Earl Warren had a tendency to be very, very liberal, and really kind of took federal government, but more than federal government, state governments to task. We talked about the incorporation doctrine. There were more cases incorporated and more concepts incorporated under the Warren Court than really any court before or after it. He, as we let's just think about a case from the past. We talked about the New York Times versus Sullivan case, and that was the case where they decided that libel and that if you were a public official, you would not be able to sue for libel unless you were able to prove malice and reckless disregard for the truth. Actual malice and reckless disregard for the truth, making it next to impossible, really, really hard, I should say, for public officials to win a libel suit because they have to prove extra things because they are public officials. That doctrine came out of the Warren Court. That case was in 1964. So that was right in the middle of his tenure. He was there from 1953 to 1969. So as we work our way through right of privacy and rights of criminal defendants, I just want you to notice the year that these cases were decided. And once we get finished with all of them, maybe you'll understand why I have nicknamed him Crazy Earl. So enjoy as we work our way through. All right, let's just talk about the right of privacy. So the right of privacy is not in the Constitution. You will not see you have an absolute right to privacy, or Congress shall make no law abridging the right to privacy. You won't see it. The first time that we really saw the concept was in some writings from weeks from earlier cases. But there never had been in the Constitution, never in any of the laws, and never in any of the cases, something that absolutely said that there was a right of privacy. So, as you can guess, this is completely common law, completely judge-made law, and the case where it was started was Griswold versus Connecticut, heard by the Supreme Court in 1965, right in the middle of Earl Warren's tenure as Chief Justice of the Supreme Court. So, I'm going to tell you a secret. Attorneys know. Attorneys know what courts are, who's at the court. They know how courts are tending to rule on certain cases, and state legislatures know it too. So they will, when there is a Supreme Court that seems friendly to their cause, they'll file cases and try and keep appealing until the Supreme Court accepts their case. Supreme Court doesn't have to accept any case. They accept only the cases that they want to. So there was in Connecticut a law that was from, 1879 something. It was old. And it was, Connecticut was highly, highly Catholic state. And in 1879, the law prohibited the dissemination of information. You couldn't even talk about or counsel people on contraceptives or how to purchase contraceptives. That was the law. And it just never was taken off the books. So, Estelle Griswold was actually the director of Planned Parenthood. And so they had been moving along. The fact that there was a Planned Parenthood in the first place meant that they were really ignoring this law. But several people had been trying to get birth control laws or anti-birth control laws up to the Warren Court because they wanted them to change the common law, and they just kept getting knocked down. They kept saying, nope, you don't have the right standing. Nope, you're not the right person. So Estelle Griswold brought a couple in, told them about contraceptives at Planned Parenthood, and then made sure that she was charged with the violation of this 1879 law. And then she appealed her conviction. People were watching from all over because they really wanted to see, number one, if the Warren Court would accept this case and what they would do with it. And the Warren Court did not disappoint. When they get the case, they basically said, we think that there is a zone of privacy that married couples should have when they are making decisions about their family and about reproductive rights. So we just think that should be away from government and away from government intervention. So we just believe that married couples actually have a right of privacy. And yeah, nope, it's not in the Constitution, but we actually think that it's there in the crevices, in the shadows of the Constitution. The word that they used was penumbras. So if you get the essay question that talks about the right of privacy, we're about to talk a whole bunch about unlawful searches and seizures. That's not what we're talking about. And if you start writing about Fourth Amendment unlawful searches and seizures on the right to privacy or right of privacy question, I'm gonna know that you didn't listen to my lecture. What the court said was that if you look at the Constitution, look at the Bill of Rights, you will see that there is an implied right of privacy. So let's just do that. Let's look at the Bill of Rights real quick. All right. So this is what they said. They said, listen, when the founders, or when, I guess, Madison, who drafted most of the parts of the Bill of Rights, wrote that there is a right of people to peaceably assemble, that means that you have a choice with whom you assemble. That must be because you have a right of privacy in making decisions about who you are going to spend your time with. Let's look at the Third Amendment. This is the only time that we'll talk about the Third Amendment. Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner. They said the reason that they wrote the Third Amendment and said that you can't be forced to put a soldier in your house was because there's a right of privacy in your house. Let's look at the Fourth Amendment. Fourth Amendment says the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So maybe the reason, because we have a right to be secure in our persons, houses, papers, and effects, is because we have a right of privacy. Let's look at the Ninth Amendment. Ninth Amendment says that there are rights that are listed in the Constitution, but that doesn't mean that there aren't any more. Just because it's not written there, that doesn't mean that you don't have other rights. And then they went on to look at the 14th Amendment. So not only did they create this doctrine as a common law principle, apply it in this situation, and give it to Estelle Griswold, overturn her conviction, and find the law in Connecticut to be unconstitutional, they incorporated it right there on the spot. This is huge. Griswold versus Connecticut is the first ever right of privacy case. The right of privacy is completely made up, but no less law than anything else. And they found the justification for the right of privacy in the penumbras. Make sure you write that down. In the penumbras of the Constitution. So let's look at that last paragraph again. Protected by several constitutional amendments, including the 1st, 3rd, 4th, 9th, and 14th Amendments by Crazy Earl. So in that instance, they made it very narrow. The right of privacy that they just created only applied to married couples and their right to plan their families. So it was very narrow. It was huge that it had been created, but it didn't apply to everybody. It only applied to married couples. So then people started scrambling, and cases keep coming up to the Supreme Court. And finally, they actually extended the right to make decisions and plan your families to unmarried individuals. There was a New York law that made it illegal to speak about or provide contraceptives to unmarried individuals. Well, the Supreme Court said, well, y'all come on into this privacy tent. So now the right of privacy is extended to married couples that are wanting to consider birth control or plan their families, and to unmarried individuals who want to plan and use contraceptives. And that's it. That's it. Nobody else. This next slide is a picture of Estelle and her friend celebrating the victory. Her friend's name was Cornelia Janecki, I'm going to say. And they are celebrating their victory in the court. So, it really kind of went on this way for quite some time. There were people that were criticizing the right of privacy, criticizing making up a brand new doctrine, but it really was not being extended. Then in the early 70s, it may have even been 1969, but the early 70s, I know, the University of Texas Law School had a clinic, and they were looking to find people that had standing, and I keep using that word. These are people that actually have something that they have been actually harmed. That's what standing means. You're the right person to sue. So they were looking for women that wanted to get abortions but could not, because at the time Texas and about 13 other states had laws that specifically criminalized getting an abortion. It just was not available through legal means in Texas. So this clinic had a lady walk in the door, and her name was Norma McCorvey. Norma McCorvey actually traveled with the circus. Norma had a child already, and her mom was taking care of the child. Norma got pregnant again, and she wanted to get an abortion because her mom told her that she was not taking a second child, but she was not able to. Not only was she not able to, she wasn't able to afford going to another state where it was legal to do it. And she did not avail herself of some of the illegal methods that were available. So she actually ended up having the child. She had the child, and she put the child up for adoption. But she's just sitting in there, and she is telling her story to the women in the clinic, and they said, "Can we file a suit on your behalf?" And she said yes. Now, when they filed the suit, they did not use her name. They gave her a fake name. Another word for a fake name is a pseudonym. Gave her a pseudonym. And the pseudonym was Jane Roe. Jane Roe. And they filed suit. She was from Dallas. So they filed suit against the district attorney in Dallas County, a guy named Henry Wade. So the style of the case, meaning the case, the parties in the case, became Roe versus Wade. Now the case wound its way up through the Texas courts, and Texas and the defense, I guess, was winning. Now by this time, Earl Warren had left the court in June of 1969, and so Richard Nixon was able to appoint his successor, and it was a guy named Warren Burger, and Warren Burger was very much more conservative. He was really kind of billed to be the anti-Earl Warren. They put him in place to hoping that he would overturn several of the decisions that had been made by the Warren court, bring some conservatism back to the court, bring some order back to the Supreme Court. So really nobody was even thinking about it when this case gets appealed from the Supreme Court in Texas. People were a little surprised that the court took the case, but they figured that it was so that they could tell states what you're doing is fine. Everybody was surprised when what actually happened was they accepted the case. They reached back to the 1965 case of Griswold versus Connecticut and decided that they were going to extend the right of privacy to women who were considering an abortion. Think about that. So they basically said that women had a right of privacy to make decisions about pregnancies. And they were very specific. The original Roe versus Wade said there is a state cannot, it is a violation of the right of privacy, this common law concept. It's a violation of the right of privacy to ban abortion within the first trimester. There's just no law that can be passed that restricts within the first trimester, the first 3 months. And for in the second trimester, they said states can regulate for health of the mother only. So they can say, you, in the second trimester, you are not able to get an abortion unless there is some serious health risk to the mother. So states get to decide, but the only thing that's going to be permissible is health of the mother. Then in the third trimester, months 7, 8, and 9, it is okay to ban or restrict abortion as long as you make an exception for saving the life or preserving the health of the mother. So that was the original Roe versus Wade. It is now unconstitutional for states to have any law which bans abortion, and any law that even restricts abortion in the first trimester. You can have laws that restrict abortion, but you have to give an exception for health of the mother. In the second trimester, you can have laws that restrict abortion, states, if you so choose, in the third trimester, but you have to give exceptions for saving the life or preserving the health of the mother. Y'all, this threw American jurisprudence and American politics into an uproar. We had never heard in the United States the words pro-life, pro-choice. Nobody was asking Supreme justices or nominees whether or not they believed in the right to an abortion. It just was not a political issue until after Roe versus Wade. So Congress jumped in, and eventually they banned the use of Medicaid funds for voluntary abortions, so not medically necessary. But good heavens, when I was in high school, I watched young ladies declare themselves independent and go and get Medicaid funds. And remember, I came from a Catholic town. A lot of hypocrisy going on, but they would go and get Medicaid funds and get abortions. It happened all the time. Well, eventually Congress said, yeah, no, not Medicaid. Medicaid is only available for those that are not financially able to support themselves. You have to be under the poverty line to qualify for Medicaid. And so basically it cut off voluntary abortions for poor women. That's the easiest way to say it. And the Supreme Court upheld the constitutionality of that law through judicial review. So time goes on, and some test cases are coming through the court. One of them was in 1989, Webster versus Reproductive Health Services, where the Supreme Court upheld fetal viability test in the second trimester before, and if a fetus was viable, then you could ban the abortion. And that, even though that made the procedure a lot more expensive, then there was a law in Missouri where the state-supported hospitals and doctors that got their income from state funds were banned from actually doing the procedure. and the Supreme Court in 1989 said that that's fine. So we're starting to see a little chipping away at the absoluteness of Roe versus Wade, which is the next huge case that we're talking about in our list of right of privacy cases. Then in 1992, now by this time, Justice Sandra Day O'Connor had been appointed. She was the first female member of the Supreme Court, justice on the Supreme Court. She was appointed by Ronald Reagan, and it was thought that she was going to be very conservative. A lot of her rulings had been very conservative. So she was a huge vote, a pivotal vote on the court. And this case makes it up to the court, and people are super excited because they're thinking, this is it. This is going to be the end of Roe versus Wade. The case was Planned Parenthood versus Casey. Now, many people were very disappointed in the Casey case. They were disappointed on both sides. Those that were thinking that there was about to be an outright ban on abortion rights were very disappointed because it did not do that. In fact, the holding of the Planned Parenthood versus Casey case was that states still cannot ban abortion. Those that were advocates for abortion rights were very disappointed because they went on to say it is okay, though, for states to legislate restrictions. And they gave us this new standard. And what they said was, as long as the restrictions don't place an undue burden on a woman. So that's the new standard. It's no longer the trimester approach. You do what you want to do. You can pass restrictions, but anytime that you do something that affects the right to abortion, whether it restricts it or not, if it restricts it, then we're going to review your legislation just to make sure that it does not place an undue burden on a woman. In 2007, Gonzalez versus Carhart. The Supreme Court of the United States, that's what SCOTUS is, upheld the ban on a particular type of abortion. And so, we're just, as time is going on, Roe is starting to take hits. The new standard is Planned Parenthood versus Casey. And states are passing laws that are restricting abortions. In Texas, the state of Texas passed a law that said you had to wait 24 hours between the time that you went to the clinic and said this is something that I would like to do and the time that the procedure was actually completed. There had to be a 24-hour waiting period. Then they went on to say that you had to have a sonogram, and the medical professional had to describe what was on the sonogram if you refused to look. Really, the law was that you had to look. Next, you had to have counseling on your other choices. So that was the first part of the Texas law. And then they got real bold. They passed a law that said that clinics had to have hospital grade equipment if they were doing abortions. So a lot of places had to go buy millions of dollars worth of equipment, or they had to stop because they weren't able to meet the equipment. They weren't able to meet the equipment requirement. They just had to stop doing the procedure. They also said that you had to have the doctor at the facility, the clinic, had to have admitting privileges to hospitals within 30 miles. In case there were complications, you had to be able to get your patient admitted to a hospital. And the way that hospitals do that, they say you can bring your patients here. And they do it on a case-by-case basis, admitting privileges. So they gave the list of hospitals, and some of them were not within 30 miles of clinics. They weren't within 30 miles of any clinic. So, what this meant was that a lot of little clinics were shutting down because they were not able to meet the restrictions. And so the case, and I am going to do your discussion board on this. The case was called Whole Woman's Health versus Hellerstedt. And Hellerstedt was the health department, the director of the health department in Texas. And Whole Woman's Health was a clinic in, I think, Corpus Christi, if I'm not mistaken. And they basically said, this is an undue burden. Basically, what you are doing is making it so expensive for women, and especially women in rural areas, because their clinics are all shutting down. Now, certainly, this is an undue burden. And that was one case, because their cases were going up to the Supreme Court, and the Supreme Court was like, that's fine, that's fine, that's fine. That case got to the Supreme Court, Whole Woman's Health versus Hellerstedt, and the court said, okay, that's an undue burden. That's an undue burden. So, really where we are these days, is that many people are still looking for that one case that will end Roe versus Wade and Planned Parenthood versus Casey, and make it so that states can pass laws that ban abortions if they so choose. Now, I don't know when this was taken. My guess is that there would be a slight difference if this was taken in 2020. But the question was, the percentage of Democrats is blue, Republicans are red, that think that Roe versus Wade should be overturned. Notice that for Democrats, the number is really low. For Republicans, it's not half, though. 46% should be overturned. And that they believe that Roe versus Wade shouldn't be overturned. Now, the number for people that claim the Democratic Party, much higher, 74%. Not overturned. For Republicans is that same 46%. The others, I guess, where I don't know. Third category. So we have talked about the right of privacy being extended in Griswold versus Connecticut to those that were seeking information about birth control, married couples. Then we talked about it being extended to unmarried individuals that were seeking information about birth control or that wanted to have access to birth control. We finally talked about the Roe versus Wade case that extended the right of privacy to women that were making the decision about whether or not to have an abortion. So there's one more category of people, one more category of people that the right of privacy was extended to. This one is a little harder to grasp. So basically, there were many states that had laws on the books that made it illegal to participate in sodomy. And but the thing about it was that these states were only enforcing these laws against male homosexuals. They were not, nobody was going and invading homes. So the case is Bowers versus Hardwick. It gets to the Supreme Court in 1986. Mr. Hardwick had a bench warrant because he forgot to come in. He didn't go to court. He had a failure to appear. And so they went to his house to pick him up. His roommate let the officers in. Mr. Hardwick was in there with a man, and he gets arrested. They were gonna pull him in anyway because he had a capias, but they charged him with the violation of Georgia's law. Texas had a law on the books as well, and there were about 12 other states that still had laws on their books that were being selectively enforced. And that was Mr. Hardwick's argument. His argument was, this is selectively enforcing only against, so really what they're trying to do, what these states are trying to do, is prescribe certain behavior that they don't like with a roundabout law. And he was like, there has to be something that is afforded to people that are in their own house. They're not doing anything out in public. The Supreme Court said, nah, we don't think so. And they said there's no fundamental right. And they upheld Georgia's law and upheld his conviction. So this matter made it back to the Supreme Court in 2003. Notice that a lot of these cases have Texas in the name. I don't know if you've noticed that. Texas finds itself on the cutting edge and at the end of a lot of laws that get changed or that get declared unconstitutional. Texas kind of gets a kick out of having restrictions just to see if the court will actually overturn them. They actually do it all the time. Well, Texas still had this law on the books. It had been upheld in 1986. Completely different situation. This was a couple. They actually lived in the house. Their neighbor called the police and told the police that there was an armed robbery in progress. So the police showed up at the house, and when no one answered the door, they knocked down the door because someone's safety might be in jeopardy, and found the couple there engaged in the act. So they arrest them for a violation of Texas's law. They were arrested, jailed, and fined. And they appealed their conviction. Now, I am not sure, but I really believe that the attorney that represented them was from the ACLU. I am pretty sure that the attorney was from the ACLU. At any rate, when the case got to the Supreme Court in 2003, the court wrote this. They said, liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. We do not want the police breaking into the home of consenting adults who are making decisions for themselves and saying, we don't like that activity. So at that time, male homosexuals, were declared to have the right of privacy. They got to have some dignity and respect for their private lives. So this is a picture of Tyrone Garner on the left and John Geddes Lawrence in the middle, and their attorney on the right. And they actually had a huge victory in many that involved homosexual rights. So that is the third of the categories. So I am going to reiterate. If you get the essay question on right of privacy, then I am going to be expecting you to have Griswold versus Connecticut, where it started, the penumbras, where the right came from, the name Earl Warren, the Roe versus Wade case, and the cases that came after Roe versus Wade, extending the right of privacy to women who were considering having an abortion. And I expect you to talk about Bowers, and then Lawrence versus Texas, extending the right of privacy to male homosexual rights. Now, if you want to start talking about the Fourth Amendment after that, fine. But when we say right of privacy, it is a legal term. It is very narrowly applied.